Now we are done with the presentations from the speakers, and we're going to get now to the discussants. As you can see that we've got two discussants, and I think before they get involved in the interaction on the stage, I will have to introduce them to you so that you should know who's speaking or who talks to you. I'll start with Dr. Anna van REBAY, who's a German lawyer and founder of Ocean Vision Legal, the first international law firm worldwide that entirely specializes in marine protection and its intersections with human rights and climate law. She's passionate about standing up for people's rights and is an experienced litigation lawyer. In her doctorate thesis, she combined this passion with her love for the ocean and investigated how states can be held liable to better protect the ocean. With her law firm, Ocean Vision Legal, she exclusively works together with NGOs, people, and communities in public interest lawsuits. Her ambition is to start a wave of ocean litigation to enforce the existing marine protection obligations in this UN ocean decade. Besides enforcing existing laws, her firm is dedicated to contributing to the development of new laws, especially those that recognize the intrinsic value of nature itself. In her firm, she is contributing to the development of initiatives such as the Universal Declaration of Ocean Rights or Ocean for Ecocide Law. She values the BBNJ as this new treaty reflects some more ecocentric viewpoints compared to traditional treaties that focus on nature as resource. One of her main focus areas and the topic of her doctoral thesis is the question whether states can be held liable to designate marine protected areas under the convention, that is UNCLOS. She's keen for the new BBNJ to enter into force and explore the opportunities for the designation of the MPAs under this new framework. That is Dr. Anna van REBAY. And now discussant 2 is Dr. Chang Youl. He obtained his PhD in international law of the sea from the Sung Yung Kwan University. He studied as a scholarship student at the Brain Korea 21 Law Program from September 2007 to August 2010 at the Sung Kwan University, and was a senior researcher at the International Marine Affairs and Territory Research Department. Korea Maritime Institute, that is KMI, from March 2011 to January 2014. He is currently principal researcher for the Ocean Law Research Department of the Korea Institute of Ocean and Technology. He has been serving as an advisor on the law of the sea matters for the Korean government and has been participating in the ISA Council and Assembly as a Korean delegation. He also has participated in the BBNJ PrepCom and BBNJ IGC, that is from 2018 to 2023, as a Korean delegation. What we're going to do now, I'm going to throw questions at the discussants. And the speakers won't be spared as well. They'll get questions as well. And I know that I can throw any question, even curveballs. They'll be able to handle them because they are experts in this area. The same goes for you. After I've done that, then you'll be given an opportunity to do the same. And you can throw any question, any curveball. It will be handled. Then, Anna, what is the main legal impediment for the effective designation of MPAs?
Thank you. Thank you, Judge JOYINI, for this kind introduction. Thank you, the President for the Korean Society of International Law for this kind invitation, President Haida for the Tribunal for the Law of the Sea, former President Park, and the Ministry of Foreign Affairs of South Korea. So your question, what is the main impediment, the main legal impediment for the effective designation of marine protected areas?
You got it.
Yes, thank you. In my opinion, I think the main impediment for the effective designation of marine protected areas, legal impediment, is the missing enforcement. We can adopt as many new treaties as we want. If we are not starting to enforce them, they don't have any effect. And actually, in fact, we already have a very, very strong treaty that also provides the foundation for the designation of marine protected areas, which is UNCLOS on its Part 12. And with regards to UNCLOS in Part 12, it has so many benefits too, because Article 192 is a customary international law with erga omnes effect, which is long-standingly recognized by the jurisprudence of the Tribunal. So it binds all state parties. It is furthermore applicable in all zones of the seas and governs all activities. So many of these questions would be solved. I see, therefore, the main impediment is that we really need to start enforcing these regulations and so develop the law of the sea. And in this third year of the UN Ocean Decade, I think and I feel there is also already an uplift in this notion and in the enforcement of marine protection obligations. We're seeing advisory opinions being requested, not only from ICLS, but also from the ICJ or the Inter-American Court of Human Rights. And we also see the readiness of ICLS to accept these advisory opinions, because the last advisory opinions, which was requested in December 2022, had its oral hearing 10 months, only 10 months after the request. So I really find very much that this shows that there is a readiness to, one, bring advisory opinions and also to answer these advisory opinions, and thus accept the role to interpret the law of the sea and maybe answer a lot of the questions that we have already heard today and that we will hopefully discuss more about. So I very much welcome also the clause in BB&J that confers advisory jurisdiction onto ICLS so that this role can be accepted efficiently. Thank you.
Thank you very much, Anna, for responding to that question. That is comprehensively so. Dr. Lee, that's your turn. The geographical scope of application of the BB&J Treaty is areas beyond national jurisdiction, which includes the high seas and the area. The question now is, if BB&J can be applied to an area because an institutional framework already exists, what happens then? Over to you, Dr. Lee.
Thanks, Judge Thembile, for giving me the floor. First of all, I congratulate on your election to the ICLS bench.
Thank you.
And I'm glad to meet you here rather than ISA council meeting. And good afternoon. It was a very long day for me as I waited my turn to debate. And I had a chance to join the PRECOM and IGC meeting as a Korean delegation, so I have honor of sitting here now. Before starting this discussion, I would like to first thank these conference organizers for giving me this opportunity to participate this great conference and to discuss this important topic. And I'm also grateful to two speakers for their excellent presentation. If you may, I would like to finish my discussion with one question to Ms. Renée SAUVÉ and one comment in relation to Professor Joanna MOSSOP presentations. And also it's going to deal with some questions raised by you.
By all means.
Okay. First, about the question, unfortunately, I did not join the informal working group and small group meeting regarding MPA topics in the Region 50 session of the BBNJ IGC because there were several meetings on other topic held at the same time. As the both presenters already explained, Article 23 of the BBNJ agreement allows all parties to object with respect to the decision adopted under Part 3, and that decision shall not be binding to the parties. However, according to the paragraph 6 of the Article 23, a party making an objection shall adopt alternative measures or approaches that are equivalent in effect to the decision to which it has objected, and shall not adopt measures nor take actions that would undermine the effectiveness of a decision to which it has objected. I completely understand what this paragraph is intended to do, but I have no idea what the alternative measures or approaches that are equivalent in effect to the decision is from a practical point of view. So it seems, I think there was a detailed discussion on this paragraph during the negotiation process in the Region 50 session. So I would appreciate it if Ms. Renée SAUVÉ, who served as a facilitator regarding ABMTs, could explain what exactly alternative measures or approaches that are equivalent in effect to the decision mean. And if any, please show us specific cases discussed in the informal working group or small group meeting about alternative measures or approaches. Next comment, Article 22 of the BBNJ agreement provide further establishment of ABMT, including MPAs. When the final proposal and drafted management plan on the establishment of ABMTs are submitted to the CORP, the subparagraph B of the paragraph 1 of this article said that the conference of the parties shall take a decision on the establishment of ABMTs. Basically, the CORP of the BBNJ agreement have a general mandate on the establishment of ABMTs, including MPAs. However, in taking decision under this article, the CORP shall respect the competencies of and not undermine relevant IFBs, and in accordance with the paragraph 2 of this article. I guess that the subparagraph B and C of the paragraph 1 of this article provides how to the COP respect the competencies of and not undermine relevant IFBs. The subparagraph B said that when the relevant IFBs have already adopted some measures, then the COP of BBNJ agreement may take a decision on measures comparable with those adopted by relevant instrument and framework and relevant global, regional, sub-regional, and sectoral bodies. Of course, in cooperation and coordination with those instrument, framework, and bodies. And the subparagraph C said, where proposed measures are within competencies of other IFBs, then the COP of BBNJ agreement may make a recommendation to parties to this agreement and to other IFBs to promote the adoption of relevant measures through such instrument, frameworks, and bodies in accordance with their respective mandates. In this regard, subparagraph B and C use words of may rather than shall. Already you mentioned Professor Joanna MOSSOP, but I think we have to read this paragraph like this, that it does explain the competencies of COP of the BBNJ agreement in certain cases where overlapping situation happen. I mean that this paragraph gives the COP a right to rather than an option to take a decision on the establishment of ABMTs. Next, we talk about the cases of paragraph B of this article. If relevant IFBs adopted some measures, then I guess we can say that the relevant IFB have the competence on that measures in the case of paragraph B. So in the first, I wondered whether the COP should only be able to make a recommendation, and also in the case of paragraph B, because the situation, the paragraph B and paragraph C is the same thing. They have both of them. They have competencies. There were my first thinking. Then I changed my mind as follows. The situation of paragraph C is where a relevant IFB have some confidence, but do not yet adopt any measures. I guess that the BBNJ agreement only provide for making recommendation in a way that respect the competencies of and not undermine relevant global, regional, sub-regional, and sectoral bodies. This is because that the BBNJ agreement is more likely to infringe on the competencies of relevant IFBs, since they do not yet adopt any measures which limit or promote their competencies. So it would be difficult to deduce what the COP of the BBNJ agreement could do in this situation. The situation of the paragraph B is where relevant IFB have some competence and they already adopted some measures. In this case, the COP of the BBNJ agreement can infer what the COP can do because it has something like a role model adopted by relevant IFBs. Regarding the scenario B showed by Professor Joanna MOSSOP and raised by you, Judge Thembile, ISA has competence of the activities on the area and the protection for the marine environment from harmful effects which may arise from such activities. And the activities on the area is exploration and exploitation in the area under the UNCLOS. So I guess that only ISA can take decision on measures to restrict or prohibit the exploration and exploitation in the area. So if ISA does not take any decision on the establishment of ABMTs, including MPAs, and related measures regarding the activities in the area, I mean exploration and exploitation, the COP of the BBNJ may only make the recommendation to parties to BBNJ agreement and to the UNCLOS. Where there are some measures such as Regional Environmental Management Plan, ISE, already developed and is developing now, the COP of the BBNG agreement may take decisional measures comparable with those adopted by ISA in cooperation and coordination with ISA. I totally agree that the cooperation and coordination is a key pathway for the COP of the BBNG agreement in establishing ABMTs. In any case, the COP of the BBNG agreement can take a decision on the establishment of ABMTs, including MPAs and related measures concerning all activities other than activities in the area under the UNCLOS. And I think the same approach should be applied in the case of RFMOS. Some may have a critical view of whether there is not much COP of BBNG agreement can do, because there are many existing relevant legal instruments and frameworks and other bodies in ABNJ. However, Ms. Renée SAUVÉ already mentioned about the strengths of the paragraph 3. We are looking at the Article 25 and paragraph 4. The parties of BBNJ agreement have the obligation to promote the adoption of measures to support implementation of decision and recommendation made by the COP of the BBNJ agreement within relevant IFBs, which they are members. So I am expecting that the legal implication of this paragraph is going to be very significant. The role of the BBNJ agreement concerning ABMTs is very fundamental to implement the conservation and sustainable use of marine biological diversity of ABNJ, and to maintain integrity of ocean ecosystem and to conserve the inherent value of biological diversity of ABNJ. I'm going to finish my discussion now. Thank you very much for listening.
Wow, that was a mouthful. Thank you very much. I can see that some of the points you raised also sort of provoked Anna next to you. Anna, let me give you the floor.
Thank you. Thank you for these comments. And I find they raise or open the floor for really a broad discussion, because also what Joanna already raised in her speech and what you said right now, what is the BBNJ's intention, how to solve this problem with other IFBs? So we've heard a lot of about Article 22. Summarizing, I think we can identify 4 situations. If you not already have, I invite you to get out a copy and read Article 22 with me, because it's quite, legal technical. So the first situation is Article 22, 1A. Very simple. There is no other IFB. The COP can just can adopt a decision. Second scenario, Article 22, paragraph 1, subparagraph B. It wants to create an ABMT that is compatible with the measure, also no problem. The fourth, and I'm jumping a little bit, or say the third, is when the measure is incompatible under C, and the fourth is actually regulated in paragraph 22, in Article 22, paragraph 7, if the MPA under COP exists first, and a later IFB will be established. I'm turning to this critical third option, that the COP wants to create an area-based management tool in an area in which an organization already exists. Now, when we look at the ISA, which is so broad, it more seems difficult, but when we keep in mind areas in the sea that may be governed by RFMOs that have a much smaller number of participants, of state parties, there is the question to me that raises, and I know you already pointed out the 2 points of views, whether the reading of Article 22, paragraph 1C and paragraph 2 suggest that the conference of parties either, in that case, when there are incompatible IFBs, may not do anything at all, or may at least establish or adopt measures for their state parties that then just are not applicable to that RFMO. And from what we've heard so far, I've felt that the opinion was more leaning towards when there is an RFMO, that COP can just not do anything. I just want to raise, just for the sake of discussion, and also for the sake that I really do think this gives a lot of potential work, future work for advisory opinions and interpretation of the law, another point of view, because I think we could also interpret Article 22(1)(c in conjunction with paragraph 2 in a way that the conference of parties at least may establish an ABMT for those parties who are not party to the RFMO. And this is because it comes down to the reading. Under paragraph 22(1)(a), the COP shall take decisions, and it does not differentiate on decisions on ABMT that are compatible or incompatible. It's general, so it applies to both. So in a way, Article 22(1)(a) is the lex generalis, and B and C, the lex specialis. So under B, do we need, in this way, we could either read Article 22(1)(c additional to Article 21(a), meaning that it can adopt a decision, A, and then C, and additionally may recommend other options. This would also be inconsistent with Article 22, subparagraph 2, which would be superficial if that wasn't the case. Because then there was no opportunity to do anything that's incompatible or undermine what the RFMO has in mind. So if the Conference of Parties did not have any competence at all, we would not need that paragraph anymore. Furthermore, Article 22(b), when it's about compatible measures, also obviously needs to be read in a way additional to A and not exclusive to it. So this supports furthermore that C also is additional. Lastly, exactly, in this scenario that I introduced, that an MPA under COP already exists and a subsequent RFMO comes into being, which is regulated in Article 22, paragraph 7, it says, and the second line from the bottom, that the MPA of the Conference of Parties shall stay in existence, and then that the Conference of Parties, in cooperation, of course, may either maintain, amend, or revoke that IBMT. So there is the option to maintain the MPA or ABMT from the Conference of Parties, even in the light of a new RFMO coming into existence, which in my opinion raises the opportunity that, or much more suggests, that it needs to be read in a way that when there is when the Conference of Parties wants to adopt an error-based management tool that is incompatible with an RFMO, it is competent to do so. It just does not apply to that RFMO. Which then, of course, raises the question of how can we kind of bring a coherent framework, because then the states that are subject to the RFMO are bound by these regulations, whereas the states that are bound by BB&J, who are not party, are bound by the BB&J. But we have already read and have been introduced to these harmonizing regulations in which state parties to BB&J shall promote in that RFMO the objectives of the BB&J, and so there can be actually ways to harmonize that. Thank you.
Wow, thank you. I told you, Thank you very much, Anna. That was also a mouthful. Who goes first, Joanna or Renée? Okay.
Dr. Lee, you raised the question about what was some of the more specific thinking in a scenario under an objection process, specifically as it relates to alternative measures. Well, first of all, let me be clear that there was no specific discussion of what alternative measures would be. Certainly in the room, possibly in the corridors, but I was not privy to that. Having said that, I do think that was a wise addition from the delegates in the sense that when we consider that for a particular area we may have conservation objectives, those conservation objectives can possibly be achieved or strive to be achieved, not necessarily just by necessarily an area-based measure. You can apply other temporal measures, for example, in a particular area that would support those conservation objectives of that particular area. So I do think that was a wise addition to that objections process, that states who are objecting to the maybe particular use of an MPA could possibly contribute to the conservation objectives for features that make that a special area by using other measures such as temporal measures, for example, and trying to maintain those special features of that particular area. So I think it gives some latitude there, which I think was probably a wise decision. One could possibly envision that a state, while wanting to pursue their exploitation interests in a particular area, could alter a design or temporal aspects or how that particular work is implemented in such a way as to mitigate negative effects on the overall conservation objectives of that area. So I do think it was a good precautionary element to at least allow that latitude.
Thank you very much, Renée. That was a good response, man.
I'm so surprised.
Joanna?
Thank you. I've got a few points to make. Just following on from that point, I would just also note that the objection procedure in the BB&J agreement was based on restrictions that were founded on the South Pacific Regional Fisheries Management Organisation, which has a similar series of restrictions to try and limit objections being made. And so for the nerdy lawyers among you, you might want to go away and have a look at the South Pacific Regional Fisheries Management Organisation, which actually has had a series, or at least two, dispute settlement processes that I know of about the meaning of some of that. So I think that's an interesting point. I completely agree with Dr. Lee about the importance of the obligation to promote adoption of measures compatible or implementing the COP and IFBs. And I often think of it similar to the implication or the result of the UN Fish Stocks Agreement. So a number of states became party to the UN Fish Stocks Agreement and a number did not. But subsequent to the adoption of that, and when states were negotiating new RFMOs or looking at adapting older RFMOs, you see the enormous influence of the UN Fish Stocks Agreement, even though some of the parties to that RFMO were not party to the UN Fish Stocks Agreement. So what the UN Fish Stocks Agreement did was it had this influence well beyond the parties to that agreement. And I think that is the same sort of scenario that we potentially could see under the BB&J. In relation to Article 22 and the difference between 1A, B and C, some of you your eyes may have glazed over there for a while, but it is, I think, going to be a really important issue. I do think that it's, that yes, you can make that distinction between measures that already exist and measures where measures don't exist. I'm not sure that it's that simple, because there will be questions about, what sorts of measures and the relationship between measures that exist in the proposals under the COP, how those will be managed. But obviously, lawyers will have an opinion about this, but ultimately it's going to be argued and interpreted by the parties themselves. So I think, one of the key reasons why states might want to think about ratifying the BBNJ relatively early is that at the formation stage, where all of those processes are being established and the COP is being established, and possibly some of these issues are being discussed, those who are party at the time that the treaty comes into force will have an influence on those conversations. So I think we also need to acknowledge that the will of the parties will be expressed through the decisions taken by the COP.
Thank you very much, Joanna. That was a good one. In the interest of time, maybe let's allow colleagues to throw the questions at you guys. And I know you'll handle them very well. The floor is open for the questions. We had our share on the stage. Now it's your turn. Vito?
Thank you. Thank you very much to all the presenters and the discussant. I just wanted to raise a quick question in relation to the coordination role the BBNJ agreement may take, which is a hopeful role in order to do something with the fragmentation and the patchwork governance framework that we had, or we have still, even the treaty hasn't entered into force. But I want to bring attention to a similar attempt on a regional scale that took place in the Northeast Atlantic, to the so-called collective arrangement between the OSPAR Commission, which is a regional seas organization, has competence to regulate vessel source pollution, and the Northeast Atlantic Fisheries Commission, which is an RFMO. And the view was, or the goal was, to include all relevant organization, global sectoral, in order to achieve an ecosystem-based management and coordinate activities that were under the competence of each of these bodies. And today, that hasn't really worked very well because of the lack of willingness of participation of a number of these organizations. And so the only really active ones are the OSPAR and the NIAFC. So I wonder if that is an ominous precedent for the hopes of the BBNJ agreement to fill this such coordinating role.
Thank you very much, Vito, for that question. Let's take other hands as well. Yeah, there's a hand down there.
I'm Wonnie Kim at the kiosk. I'd like to ask a question about the what could be the motivation of the IFBs to harmonize their policies or their measures compatible with the measures from the BBNJ COP? Because when Joanna showed us such interactive maps among the BBNJ COP and the other IBFs, you showed us some vertical maps. So BBNJ COP was upper side, but the other IFBs were under the BBNJ COP. But in reality, it's a very horizontal system. So as Anna already mentioned, there is no enforcement action. And to my mind, there would be no such a thing to enforce the BBNJ provisions towards the third parties or other IBFs. So what could be the motivation of the other IBFs to harmonize their measures and policy with the BBNJ COP's decision or measures? Thank you.
Thank you very much for that question. Is there another hand? Maybe let me share this with you. this is the first and the last round. There will be no second round. So if you think that we are reserving your question for the second round, you better ask it now. There will be no second round. Oh yes, Judge Brown?
I just really want to thank everyone. That was just really very stimulating. I made a number of notes, but the only two little things that I'd ask you to expand on at this point, since I haven't heard any further development after they were presented, was one, dealing with the notion that the climate change might trigger the emergency measures, and the other was a mention of having port state measures as a possible means of enforcement. So I just wonder if maybe there could be a little development of those two concepts. And thank you for the very stimulating discussion, particularly on Article 22. I thought it was very, very interesting to hear. Thank you.
Thank you very much, Judge Brown. 3 questions. Oh yeah, there's another hand there. That will be the 4th question.
Thank you. Thank you, Mr. Chairman. I learned so much this session. I have very simple questions. My question is to Dr. Anna. Just read your career. So you mentioned the Universal Declaration of Ocean Right. It was very interesting to me. So yeah, when I was in Germany, I'm writing my PhD. At that time, the new concept, human, so common heritage of mankind. So at that time, it was very, very popular academic topic. Is the legal principle or international policy principle? So I am wondering, could you please more concretely the Universal Declaration of the Ocean Right regarding BBNJ? It's my question to you. Thank you.
Thank you very much for the question. Then I think it's now time for responses from the stage. Yeah, Renée, go first. It's fine.
Okay, I'll try and be quick. Maybe just in reversed order. With respect to enforcement and port state measures, I was really throwing that out there. And I think, we're far from that for a couple of reasons. The delegations clearly do not want a non-punitive approach, certainly, and for the foreseeable future, I don't think there's really the economic levers to really take that, sort of market-based approach for enforcement. But, who knows what might happen in the future. With respect to what is an emergency, and as I said, Article 24 came in kind of late in the process, and we really didn't have a chance to have a lot of discussion on that. But I think that's an area that will definitely need more work. The limited discussions we had in the room revealed that, and it was it New Zealand who was, New Zealand was the champion proponent of this article. Certainly in the initial discussions, that's not what they were thinking, that there would just be this general trigger for emergency measures, and there seemed to be some understanding in the room, but the devil's always in the detail. So as we go forward and we start having more detailed discussions of what would an emergency situation be? What would that look like? Then I think we'll find out how that evolves. But certainly the initial discussions, delegations, there seemed to be a general understanding that it wasn't something so broad as that. Just quickly, we had the point about what's the motivation for coordination? I'll just comment quickly, but I think other members on the panel will probably want to touch on this. I guess one avenue of motivation is if you know, a BBNJ party is also a member of, say, the RFMO. So there's going to be some, not only motivation, but a certain degree of obligation there to promote that coordination. And well, compliance really in this agreement is really taking a non-punitive approach. There is much transparency built into seems like every section of this agreement. And there's that saying, there's the best disinfectant is the light of day. So, you know, in the fairly plugged-in global public we have, with a lot of this information and decisions being made public, I think there's might be a certain incentive there for delegates and states to take fairly credible positions and objectives that are consistent with the agreement that they're party to. So there will be a certain amount of, I guess, public political pressure in that sense. So that might be a bit related to the motivation also there. And just finally, and I probably shouldn't comment too much because not being part of that OSPAR process, but yes, your question was, is this an ominous precedent? I would like to think the opposite, actually. I give much credit to those regional organizations, OSPAR for the work they've done, and NEAF and how they've really stepped out to try and deal with these areas beyond national jurisdiction. So I think, you know, it's notable the leadership, I guess, that they're trying. But, you know, it hasn't gone completely smooth. And because we do have our fragmented system, it's a very piecemeal going one-on-one with a cooperative arrangement. And it's a pretty process-heavy process, and it takes a fair amount of energy and time. So one would hope with the BBNJ, with it being you know, the focus of biodiversity beyond national jurisdiction, in fact, should be the answer, should counter that, that necessity to go out on kind of a one-by-one basis. Having said that, the agreement's very new. We don't even have the structures set up, but there is a commitment for the Secretariat for BBNJ to provide that convener role in relation to IFBs. So there's the commitment, there's an identified role. As the structures get established, and of course with adequate funding, one would hope that the BBNJ, in fact, would improve upon that collective arrangement, kind of a piecemeal process. So that would be my response.
Thank you very much, Renée. Joanna?
Thank you. I might comment on the first two questions, which I see slightly relate to each other, because I guess the question is in the Northeast Atlantic, you know, what was the motivation of the IMO to turn up, or the International Seabed Authority to turn up and talk about this? And obviously there was a small subset of states that wanted that engagement, which possibly in the broader context of the organisation's membership was relatively small. In contrast, from the beginning of the negotiations for the BBNJ agreement, we saw a lot of international organisations turning up at the negotiations because they knew that this was going to be a place where their activities might be under scrutiny from the international community. And so even though we do have the outcome that, you know, the COP can't override the decisions of the IFB, they know that there is going to be a lot more attention placed on their activities in relation to biodiversity than there has been in the past. And so the mere existence of an international treaty and international processes means that those organisations are going to be perhaps under scrutiny that they haven't experienced before because of the wider membership. And I didn't dwell, I had on my slide, but I didn't actually speak to Article 26, paragraph 2, which says that IFBs shall be invited to provide information to the conference of the parties on the implementation of measures they have adopted to achieve the objectives of ABMTs. Now, that is not a requirement on those IFBs to turn up, but you can imagine, you know, the response if an IFB refused. And certainly the states that were party to the IFB and also party to the BBNJ would be asking some, I think, serious questions about that. So I think the motivation is the global nature, the transparency, and really a lot of opinion. I just think there's going to be you know, a lot of attention, and that is going to motivate these organisations to cooperate.
Thank you very much, Joanna. Anna?
Thank you. Thank you, Mr. Lee. I would like to have the opportunity to answer your question because it is an interesting point, also reflected in the BBNJ. So you asked me about the Universal Declaration of Ocean Rights, which is a process understood or aiming to grant rights to the ocean. So it is a process or a movement within the broader framework of what we call rights of nature. The development of rights of nature is a relatively new concept. It has older roots, but it is just experiencing kind of a rebirth. And what it aims for is to recognize that nature itself has intrinsic value and is not just a resource for humans. So the traditional treaties, in international law especially, usually regulate nature as a resource. For example, the UNFSA, the United Nations Fish Stock Agreement, in its title already shows that it regards fish as a stock. Or and likewise, other treaties have the same language. So what rights of nature really aim for is to have a shift in the mindset of people's thinking away from this anthropogenic worldview in which we think we humans are the center of everything and we can use everything as a resource, to a more ecological or ecocentric worldview in which humans understand that we are part of an ecosystem, but we do not dominate it. This also goes along with a movement called ecocide, an ecocide in the ocean space, which at the same time, as much as ocean rights grants rights to the ocean, like we have the right to life, ecocides establishes the crime to destroy the marine environment. So like we have the right to life, which is protected by the prohibition, by the crime of murder, ocean rights can be protected and the violation of ocean rights can be prevented by establishing ecocide in the marine environment. The Universal Declaration of Ocean Rights is a movement, is a process that aims to adopt this declaration for the ocean by 2030. And with regards to the BBNJ, I'm very happy to also, with regards, besides all these legal elaborations aside, which I love, but besides all that, the BBNJ, no matter how we interpret Article 22 or the emergency measures, very, very much carries a message. Because in itself, adopting a treaty like this has authoritative power. We actually have other means in international law that are not legally binding and still have an immense effect. The advisory opinions. Advisory opinions in itself are not legally binding, and thus they have such an authoritative effect. And likewise, even if we were to come to a result that Article 22 needs to be interpreted very narrowly, the BB&J still has very much an authoritative effect and thus contributes to the development of law, because it can also contribute to the development of customary international law. And what I very, very much welcome of the BB&J is the change of language, which does no longer speak of fish stock. On the contrary, in the preamble, it says, desiring to act as stewards of the ocean in areas beyond national jurisdiction on behalf of present and future generations by protecting and caring for the marine environment. So saying desiring to act as stewards of the ocean very much carries the notion of rights of nature, because what do we need from a legal perspective to establish rights of nature? Well, a whale or the ocean will not be able to go into the courtroom. But we have also other legal constructs in which we have representatives, or as it says here, stewards. Because corporations also don't walk in the courtroom but have representatives. Children have representatives. So it is possible, and very beautifully, rights of nature, this approach is thus also implemented and reflected here in the BB&J, which I welcome very much. And this shift in language in the BB&J carries the shift of the mindset. And besides all these legal specifics, may, in this third year of the UN Ocean Decade, really, really just bring upon this shift in mindset that we need if we want to achieve this paradigm shift in which people don't use nature as a resource anymore. Thank you.
Thank you very much, Anna. Dr. Lee, you can have the last bite.
Very shortly, regarding motivation for harmonize between BB&J and 11 type BB, my thinking, there is not a problem of motivation. As I already mentioned, promoting measure adopted by the BB&J is obligation parties to BB&J. So is a problem about the obligation. However, my suggestion for raising a motivation of the 11th IFV, first suggestion, BB&J COP give opportunity to have a conversation, a communication place to talk about common goals together, all relevant parties. And second suggestion, BB&J can facilitate joint scientific research about specific areas relevant to IFV is interested. That's it. Thank you.
Thank you very much, Dr. Lee. Program Director, Excellencies, ladies and gentlemen, it cannot be better than this. Let's give them a big round of applause.
Thank you. Thank everyone for your enlightening speech. And ladies and gentlemen, once again, please give a big round of applause for our speakers and our moderator, Judge JOYINI, for the great session.